Cultural context. In our culture, an engagement ring that accompanies a proposal of marriage is usually considered to be a gift for a promise of marriage. The underlying assumption is that the gift of an engagement ring is exchanged as each party's promise to marry the other. California Civil Code 1590. California Civil Code 1590 addresses this type of gift. It states, where either party to a contemplated marriage in this state makes a gift of money or property to the other on the basis or assumption that the marriage will take place. In the event that the donee refuses to enter into the marriage as contemplated, or that it given up by mutual consent, the donor may recover such gift or such part of its value as may, under all the circumstances of the case, be found by a court or jury to be just. The rule. Donee is the person who received the ring. The language of this statute suggests that the recipient must return the ring or the value of the ring if the following occurs. 1. The recipient decides not to marry, or both parties mutually decide not to marry. The California courts have interpreted this statute to mean that the recipient usually has no legal duty to return the ring if the donor, the person who gave the ring, refuses to marry. The wild card. Even though the statute specifically applies to gift in contemplation of marriage, legal principles of fraud and other defenses for breach of contract may apply. These principles are numerous, complicated, and conflicting. One can never predict how a judge or jury will interpret or apply any of these principles. One can never predict what evidence will be brought to the court's attention, nor can one predict how or even whether a judge or jury will consider or interpret that evidence. Statute ambiguity. The statute itself is not entirely clear. It states that the donor, open quotes, may recover such gift or such part of its value as may, under all the circumstances of the case, be found by a court or jury to be just, end of quotes. May does not mean will or certainly. It means maybe, and one can never predict what a judge or jury will find to be just. The takeaways. The rule probably depends on who refuses to marry, and it plays out as follows. Recipient refuses to marry for reasons other than fraud or fault of the donor. Recipient returns the ring. Donor refuses to marry due to no fraud by or other fault of the recipient. Recipient keeps the ring. Third, both parties jointly decide to cancel the marriage. Recipient returns the ring.